casually, see, make sure it's working. I think it's working. The light is, you don't have to look in the camera. Don't worry about the,
That's a whole new level of stress.
Yeah, don't worry about that.
you look like, it's like the deposition. They have cameras in depositions, don't they?
They do in their mind.
So,
Okay. We do camera depositions.
I'm going to start, and then you're going to do your thing.
Sure.
First of all, excellent job in the work. I can tell you put a lot of time and effort in, particularly your search of case law. So, of all the candidates we looked at, you had kind of an interesting take on it. So, with that as an intro, give us your best shot in 10 minutes. Go.
Okay. Well, I guess I saw the court errors falling into two different categories. The first of those was that it went off into this hypothesis of void versus voidable without any guidance from the litigants themselves. The second issue being that without that guidance, they sort of fell victim to their own confusion and created a conflict where there was none when the statute, I believe, is clear. Now that first issue, I think, is the most direct attack on Bassman. In the court's own words in the denial of the rehearing, they explicitly said the primary reason for them ruling against the Bassmans was the Bassmans' failure to carry their burden of persuasion as to the issue of void versus voidable. So it seems to me that the rest of what followed can then be said to be primarily dicta, therefore not binding, and is only valuable for its persuasive value. I think the second issue goes directly to that lack of persuasive value. Looking only at the case law that's followed, I think that becomes clear that courts have agreed with that. One court seemed to think it was following Bassman and took it in a way that I did not see Bassman as standing for at all. Another court sort of looked at the confusion and then tucked its tail between its legs and ran away to decide the issue on the merits, avoiding the issue of standing. I think the reason for that is clear when you look at the actual analysis itself. The statute comes straight out and says that every act in contravention of the trust documents is void, except where the statute or the trust documents say otherwise. And from my view, it looked like the court looked at that every and then just ignored everything that followed the except clause, not realizing that every was qualified by the except. So when it saw case law that looked to agency principles like apparent authority or ratification, it went, well, wait a minute, if it's not void or if it's merely voidable, how does that fit into the every? When agency principles clearly fall within except as otherwise recognized by the law. The first issue it created conflict was with apparent authority, so a manifestation from a principal to a third party that reasonably allows a third party to believe that an agent is authorized to act on behalf of the principal. It looked at some case law where that was possible. However, in these facts, it did not seem possible at all. You have an ongoing series of transactions between Heller Financial, Morgan Stanley, and Bank of America, all of which are structured in a certain way not only to satisfy the PSA, but also to satisfy the REMIC requirements necessary to get the favorable tax treatment. So for Heller to try and argue that they reasonably believed that changing from this ongoing course of conduct they have been undergoing is just untenable. There's no way they could believe that after going through a series of transactions necessary according to the law and the terms, they were somehow excused from those by some sort of manifestation towards them on behalf of the trust. And I don't think the court really relied on its apparent authority argument too much. The one that seems to have caused the most uproar on the blogs and the more interesting part of its analysis, to me, was the ratification issue. That is where a beneficiary of a trust can ratify the ultra vires actions of a trustee post hoc. The court's analysis here seemed to just reduce the statute into sort of a circular absurdity. It said every act is void, except every act in contravention is void, except that when an act is in contravention, it can be ratified, so it's merely voidable. So every act is void, except it's merely voidable. That seems to go against the tenet that the court cited itself, that every statute should be construed so as not to create absurd or meaningless results. Now it uses that same tenet to strike down the idea that the Bassmans could use this statute to defeat Bank of America's claim. That conclusion to me just seems unreasonable. the court seems to think that, or rather, let me rephrase. Every legislature can be presumed to be attempting to achieve some sort of just results. By denying the Bassman standing in this case, they're not only denying the basic fundamental principle of the law, that every person has a right to own their property and no one can take it from them unless they themselves have a legal right to do so. By denying the Bassman standing, they're not only denying that fundamental tenet of the law, they're also denying the Bassmans their individual protection, that were they not able to argue this claim, a later creditor, the true owner of that claim against their property, could then come against them in subsequent multiple liability. So for the court to say that allowing the Bassman's argument in this case is unreasonable or absurd, it cannot stand in light of the fundamental interests allowing them this argument would serve. I guess in sum, I think had the Bassman's counsel actually litigated the issue as the court requested them to, they could have easily been made aware of the fact that these apparent authority and ratification doctrines clearly fall within the except clause. Apparent authority was not possible in this case, and the court's interpretation of ratification is unreasonable. And in my nervousness, I skipped over. I think what the court did in so broadly defining ratification missed the mark. I think ratification is only possible, and in this, this goes back to basic sort of restatement of agency principles, which are recognized in New York, that ratification is only possible when the beneficiaries are fully made aware of the nature and the legal effect of the transaction. Absent that, it cannot be ratified, so it remains void until that step is taken. And I think the Bassmans could have easily shown that here, because not only was it not done, but it would not have been done, because had the beneficiaries been made aware, they would have known they just lost their favorable tax treatment for not complying with the PSA. That's about my summation of my argument. I went pretty quick, didn't I?
No, you did great. What I liked best of what you did, Andrew, was your analysis of what happened after Bassman. Talk about the two cases and why you believe that there is a foothold for foreclosure defense. I thought that was great analysis.
Let me get the case names up.
One in Texas and the one right here in Illinois.
Yeah, the one in Texas, Uranus, seemed to take Bassman for the idea that you have these huge pooling and servicing agreements, so every minute detail doesn't need to be followed. And if a trustee just makes a tiny mistake, then Bassman will excuse it. I didn't see that in Bassman at all. I saw Bassman standing entirely on this void versus voidable distinction. Never really mentioned the fact that this was a tiny mistake. It did use some terminology to try and downplay it, calling it an ultra vires action. But I definitely didn't see how Uranus came up with the argument that Bassman stood for that proposition.
And the second case?
The second one was
Saucedo?
I thought that was pretty funny to me. They sort of looked at the issue, looked at the most recent case law in Bassman, and then just sort of panicked and ran away. They said, here's the law, here's what the law says, now here's what Bassman says. And I could sort of hear the court going, uh-oh, and then they decided, well, we're going to avoid having to rule on whether Bassman is right or deal with this issue at all, and they went on to just decide the merits of voiding standing.
Were those the only two cases you found post-Bassman?
The only two that I found post-Bassman, that cited Bassman. I think there might have been one other one that cited the 7-2.4. I can't remember how it ended up going, but I think it was a Texas case that turned on the state grounds.
So given the Saucedo case, what would you be inclined to do if you were going to write a motion to dismiss in federal court based on everything you've learned in this exercise?
I think the first step would be sort of a strategic decision as to whether or not we should address Bassman up front. Because from my point of view, Bassman's not binding. The reason it was dismissed was the litigants didn't argue the issue. So I guess if I were to write a motion to dismiss up front, I would start on arguing the issue. And if someone were to then come back with Bassman, we would already know that the Bassman court explicitly said, no, the reason I dismissed was because the issue wasn't argued. And then in the second part of the argument, in a reply brief, we could attack the idea that Bassman's sort of hypothetical dicta has any persuasive value.
Hopefully you'll be more successful at that than I've been.
Yeah. That is chuckling.
How have courts been taking? They take the Bassman statements as binding.
Where it's almost laughable.
You ain't got no standing, boy. That's
It's
how they
like
take it, okay?
it's just like a general conclusion. It's like they don't even read the case. So
Yeah,
they're
I mean,
not on point.
they don't, yeah, yes. Yours is very, we like the reasoning that you come up with. We like the way you got there. I have been thinking about hiring 1.5 attorneys as well. And I don't know how that fits with your thought process, because I haven't made up my mind on what I'm going to do, and I've talked really to anybody, and we've done this so that we can get John involved as well. But our thought process is yeah, we'll bring one person on full time. We might bring one person on 20 hours a week, and in 60 to 90 days, move ahead. And part of that is because of our own internal, did I say this, weakness, that we're not sure that we have the strength to bring 2 full-time people on at the same time and manage them and do all of the stuff that you really need. And I don't know, how would you feel about if we did half of it instead of the whole thing? Trust me, I'm going to ask everybody this question, okay? I may not ask everybody, because I may not hire them, even be interested.
The Cliff Note version of that is you've created a problem for us because we really like you.
Okay, that's good.
So we need to think outside the box creatively. How do we get your legal mind on board?
Well, I definitely wish I could be the one, but if it came down to the half,
You should say this so you don't feel quite so bad about that part. I have a great predilection to go to somebody who's got a year to 2. He would like more, but I would like someone with a year or 2 of litigation experience in a defense firm or a PI firm, or even somebody who's been doing foreclosure work, although I don't think they necessarily get all of the things that we're interested in seeing somebody do, so that they can come in and really pick up and run right away.
sure.
Okay? And that's the part where I talk about 60 to 90 days, because I need to bring somebody up to speed so that they can jump in and have somebody else to watch, and at the same time we're training that person. I just don't know that I could do it all at the same. I'm trying to be honest with you.
Sure.
I'm not Superman, okay?
Yeah.
This would go to the point we raised in our first interview that you would really have to put a lot of time and get up to speed yourself, because we have the predisposition that you're not ready to be in court tomorrow. But
Sure.
you are ready to help us.
Okay.
Big
Okay.
time.
You,
Yeah.
you see what I'm saying?
Mhm.
And so we need a resource that could be in court, but we also need the others. So you've actually made us think more about how we might be able to do something. And given your interest level, I'm assuming that after hearing the Wooten podcast, you'd like to be the warrior lawyer in foreclosure defense.
Yeah.
So
It'd definitely be something I'd be interested in. My only concern is I think come June or August my student loans start hitting, so I'd feel a little bit.
How do those, I know nothing about loans of that gargantuan size. I mean, I was lucky enough to survive Vietnam, and since I did, I got most of my college paid for, okay? And most of my law school, rather, paid for, okay?
Yeah, I avoided
So
the
I don't
college
have
loans,
those,
but I
I don't
racked
have
them
those
up.
issues, and I don't really know anything about it, other than those are really crappy problems.
Yeah, they give you a 6-month grace period. So I graduated late December, so I have till June or the end of June, something like that. And then they start coming in. I think they base it on how much you're earning, or there's
Well,
also
we can
a
take care
minimum-
of that problem. So you're very,
There's also a minimum payment. So that would be my only concern, is that I'd feel like I was a little bit on the cliff. If you decided to go a different direction at the end of the 90 days, I'd be in a little bit of a pickle. But it would definitely be something
You'd
I'd be
have to,
interested in.
if I decided that you were that person, either we would have to run out of money, which I don't think is gonna happen, or you would have to be a total washout.
I doubt that would happen.
That's your issue, okay? I mean, I can understand that. We don't think so either. We wouldn't think so either.
And obviously in this part-time 20-hour scenario, you're obviously free to manage your time because we can't command that of you. And I'm sure you could think creatively to do some other things too.
Sure.
I mean, part of your challenge is how do you manage the workload and do it. And someone once told me, give me a reason why I should spend more time. And by you actually doing lots of good work, Ted won't resist and say, hey, I know you can help me. So a lot of it's on you. It's like, look, how much can I do? Based on what I saw, I mean, you tell me how much time did it take to deliver this product?
I was thinking this on the walk over. I think it was probably like 3.5 hours, 4 hours of research, and then 4 hours, or probably like 8 hours total, maybe a little under.
Okay. If that's true, start to finish, that's awesome.
Good.
Because we're going to have lots of these in replication.
Good.
And we'll have somebody. The last question I'd like, do you play well at the playground? Can you work with someone else who can work collaboratively on these?
I've been a basketball and baseball player my whole life, so I've always been on teams. I work well in teams. As long as everybody works hard, I do great.
And I think did we talk about the bankruptcy background?
We did it the last meeting for a little bit, I think.
As it turns out, that might actually come in handy. And we don't have time to get into it now, but that's something that Ted and I both saw that the bankruptcy background will certainly help in the event that we may have some clients in the off chance that they need to file a BK. And I'm assuming that you're ready to handle that.
Yeah.
We just can't figure out how to make money.
Tracy had that problem too. They have lots of phone calls to collect.
Yeah, I mean that's our